It's true.
Okay. So, welcome everybody. Good evening, I think, to most of us. Good morning to Samir, and probably good afternoon to you, Peter. And yes, so this is, in the practice of law, this is a very interesting phase that I think every country goes through. And it's interesting that it is sort of happened in, as far as India is concerned, just now. Other countries have been through this, and I think the objective of, especially from an ILA perspective, is that we any aspect that affects the practice of law, whether in a country or otherwise, or any topic of interest, we will happy to discuss this, debate this, and also, you know, sort of what is the impact that is the main sort of concern. And so I'll just before handing it over to Suhas and Samir and others, I think couple of things. I mean, I personally, I had sort of visited Canada and British Columbia about over 10 years ago, and that is the first time that I came across this issue of the foreign lawyer practice and things like that. Of course, over there it is very highly regulated. The law society sort of takes charge. You have to pretty much sort of uh, give your credentials. You have to get no objection certificates from the local, not only the bar association but the bar council as far as India is concerned. And the that uh, that is an aspect which I think is very sort of common, as I saw in other Commonwealth countries as well, where you apply for it and then they give you a sort of a limited practice of the law that you have been practicing. And of course, this is again very different from the limited, the fly in, fly out. I think most countries have it for 40 or 60 days. You know, yes, there are some countries that say, nothing doing, and, there is no practice, and you have to use a local lawyer. But those countries are also, very few. I think, uh, uh, yeah, I think I'll pause here. I mean, we must remember that this is again an issue which has been through the courts of law in India, and that's how it has actually come to this stage. And yeah, I'll pause here, and maybe Suhas, you can take it ahead.
Yeah, sure. Jamshed, thank you very much. Again, good morning, good afternoon, good evening to everybody. Uh, Welcome to this ILA kind of a session. We were expecting far better response, but I think maybe we are in the middle of week and there are lots of other priorities and commitments. But we are recording this and we'll make the recording available subject to everybody's consent. So, an important topic, yes. Is it? I mean, I completely agree with you, Jamshed, that this is one of the very critical steps or landmark steps in the legal profession in India. But I just want to go way back, 1998 probably, where uh, India took an obligation saying that gradually over the period of years, we will allow international trade. We will allow international trade in law. So there is a paper which was although it's a restricted circulation by Government of India, but Government of India recognized as far back as in 1998 that there ought to be liberalization of trade insofar as legal practice is concerned. There is a OECD report which is available that talked about what are the restrictions, right, from barriers that have been created artificially. And there, I think we did a kind of a survey at that point in time. As to trade in legal services, the what are the trends and how does this translate into, let's say, liberalization of Indian trade, whether it is by individual lawyers or partnership firms, and how the commitments have been taken. This is known as legal services Uruguay round of commitments. And there are various countries which took commitment of saying whether we will allow reciprocal, we will allow partial, we will allow full market access. And based on the international classification, the advisory, the representation, or in terms of host country law, advisory representation in terms of international law, and home country law, etc., were kind of mapped across and articulated in such a manner that there is a way forward insofar as international trade is concerned. You see, after that we have seen, and which is part of the preamble to the rules, there has been one Bombay High Court judgment, there has been one Madras High Court judgment. Both of them went up to the Supreme Court. Then Supreme Court came out in Balaji's judgment as to what needs to be done. And three things that were talked about. One is how do you treat fly in and fly out kind of a legal practice? Is it practice of law when something of this nature happens? Secondly, if the foreign lawyers were allowed to practice in India, what are the restrictions and how do you want to regulate it? Was the question that was asked to Bar Council of India. And the third question was broadly in the nature of, and which is again, in my view, one of the important kind of a question that gets unanswered till now, is about what do you do with respect to the BPOs or LPOs as we understand, or legal tech companies that operate across the board. I think that question still remains unanswered. But based on the directives that the Supreme Court issued and the kind of rules recognize this very clearly in the preamble, in the statement of its object and reasons, that this is arising out of what Supreme Court asked us to do in terms of preparing these rules, and therefore we have prepared these rules. Now that's the background with which these rules have been framed. It's not that it is following the commitment that we have taken as a country following the GATT negotiations and the World Trade negotiations. It is following the Supreme Court diktat or Supreme Court order that the Bar Council of India came out with this regulation. Broadly speaking, therefore, intent at the government level, having undertaken commitment at the global level to liberalize the trade in legal practice and legal deliveries, legal services, is different from what Bar Council today has come out as a rules. And therefore, there is a huge gap when we talk about foreign law practices being permitted. That's not arising out of the obligation from any other treaties that internationally governments have undertaken. It's arising out of a mandate that Supreme Court gave. Now, the difference, and we all know the difference between a law in India, which is part of the Constitution of India, that only central government is permitted to bring out the law, which is arising out of the bilateral treaty obligations or global treaty obligations. Bar Council of India coming out with these rules is not in aid of liberalization of law practice. That's my view. I'm happy to discuss. If anyone has any other views, happy to listen and understand. Samir bhai, you want to add on something?
Yeah, I think both you and Jamshed actually pinpointed the the issue behind the current notification. My take on this is that if we actually read the notification, there is nothing new as such which has been made therein. I mean, this kind of so-called opening up was already there as such The only thing is now that had been notified. Now, giving example of, let's say, US, because I've been doing here now, there are two places where, as a foreign law, you can register straight away, where your, let's say, the Indian LLB degrees will get recognized. One is New York and other is California. And these are the only two states which also allow you to sit in the bar examination based on your Indian legal degree. However, there is a long process. It takes almost 6 to 8 months to first get your degrees assessed, and then they allow you to sit. In majority of the cases, you have to go through the US LLM part, and then you are allowed to sit. So coming back to this notification, what it says about the reciprocity, I think that's the important catch there. The whole notification, if you read, is based on the reciprocity. And to me, I mean, I may be wrong, but to my knowledge, there is no such reciprocity with any other country where Indian degrees are recognized. Probably in UK, I'm not aware. Somebody can, I mean, throw light on that. But as per my knowledge is concerned, Indian law degrees are not straight away recognized in any country. So there is no reciprocity as such. Now, this aspect, this particular term, reciprocity, is not defined. It's not explained. It is not elaborated. So what exactly means by reciprocity? That's one part. Second, they are more focusing on the international arbitration. Now, that was anyway going on before. There was no problem in that. In fact, this issue came up a couple of years back of these international arbitration practitioners coming in and going out and all. And there was an issue raised by the Indian taxation authorities on this. So that was anyway going. So I don't think that is anyway going to help. Now, today, let's understand from the foreign law firm's perspective, or the foreign lawyer. What this notification says, that now you can open your office in India, but you're not going to practice Indian law. You can practice your own law of your own country. That's what it's restricted. But so ultimately, why a foreign firm would come to India and practice his own law here in India? That's another question. Now, this could be an implication of the current FTA's discussion which is going on between India and a couple of countries, including UK and US. This could be a fallout of that to, sort of give a comfort level to the foreign investors that you will get your own country's, law practice and all here in India. But again, foreign investor coming to India don't look out for a law of his own country. They would be looking out for the Indian law because they are investing in India. So these are the issues. I think these are still open-ended. I am not sure how this notification going to actually help, or maybe an adverse impact on this. This needs to be discussed, elaborated. And recently, I think I shared there on the group about this committee being formed by the big law firms of our
Senior
country,
lawyers,
and
correct.
they have made representation to BCI, and that they are actually talking about this aspect only, the reciprocity. Basically, there is no reciprocity as such, to my knowledge. So this is still an open-ended discussion how this notification going to actually help or support the foreign law firms coming to India or the lawyers coming to India, and how it is going to impact us at this stage.
So Samir bhai, I'm a kind of a hopeless optimist, if I were to put it that way. So in whatever this entire rigmarole that is there, I'm trying to look out for those very fine nuggets which will be positive nuggets. So let's look at what the law says insofar as fly in and fly out practice is concerned. One of the questions before Supreme Court in Balaji was, fly in and fly out, does that amount to practice in India? Okay, including the grammatical variation, including all other, similarities with other professionals. What came to the light that if somebody is doing a fly in and fly out and advising Indian clients or foreign clients on the foreign law, is that prohibited? Is that restricted? Could that be regulated? The answer came in very clearly through these rules, not even at the Supreme Court judgment level. And to that effect, when there is a prohibition that is being talked of, saying no foreign lawyer would be permitted to practice law in India unless these rules permit it. That's the prohibition mentioned there, correct? It says that this will not apply to fly in and fly out. And fly in and fly out, it's 60 days in a year. I think that gets specified, and I'm seeing that as a huge, opener, so to speak, huge positive point today that this is revalidated. Although we probably know that unofficially people were flying in and flying out and advising, but this now becomes an official channel. This now becomes an authorized practice of law in India, fly in and fly out, authorized practice of foreign law in India, and therefore it gets that legitimacy. That's one area. The second area that I actually say is that even though the question of Indian law may be involved, if it is international commercial arbitration based on international law impact, so to speak, then that would be permissible. Now, that's another huge door opener there. So I'm seeing these three nuggets out here in the existing rules, which are very, very positive, notwithstanding whether you are registered or unregistered.
No,
But large,
sorry.
yeah,
Yeah.
Samir bhai, please go ahead.
No,
Please
no,
go
no,
ahead.
no, please. No, you complete. I'll come later. Yeah, please.
Yeah. So when we talk about these areas, to kind of you know who is a foreign client? That's another very important kind of a definition that has come in. And foreign client means an individual who is or who are foreign citizens, etc., etc. Firm, corporation, business entities having registered office in a foreign country with a branch, regional office, or manufacturing unit in India. Now, therefore, if I were to kind of ask Peter, saying let's look at any of the large Swiss companies that are operating in India today, and you take the case of most of the multinationals who are registered there, who have head office there, they will be foreign client for foreign firms. And that's where probably I think large Indian law firms are getting scared. Pardon my saying this, but the issue then would be if the foreign client, which is a foreign company registered in Switzerland insofar as Peter is concerned, who has a subsidiary in India, a manufacturing unit in India, a branch office in India, or a regional office in India in whatever form. So it has a legal entity in India. That client for Peter would be foreign client. Now, application of Indian law versus application of foreign law will also have to be addressed. But in my view, therefore, this becomes an authorized practice of law in India for foreign client. Maybe the relationship between the parent and the subsidiary was always under Swiss law insofar as Swiss companies are concerned. You see, you had this trademark license agreements in the pharma company where the parent was actually licensing the trademarks to a subsidiary in India, which is a manufacturing unit. And that licensing arrangement was always controlled via substantive Swiss law being applied to it. Is that the kind of practice that would now be considered as authorized practice in India? And the answer to that is a huge yes, according to these rules. So these are few of the nuggets. I mean, when you talk about international arbitration case, it talks about international arbitration case in India, where all parties are persons who have been an address or a principal office in foreign country, etc., have submitted to international arbitration case. So there are quite a few of these elements where probably first time we have seen legitimacy coming out for these practices. Now, you see, therefore, I'm very positive. As I said, I'm a hopeless optimist. I'm very positive that while the top law firms in India will continue to fight on reciprocity, I think if fly in and fly out is completely outside the purview of registration, and the fact that foreign client means a principal office being in a foreign country and its subsidiary, its registered office, branch office, its regional office, its manufacturing unit in India. I think large part of issues could get addressed insofar as competition coming in India. As a first step, I would definitely say very well played. You tried to kind of focus on reciprocity, but you let go of few of the elements today, which will allow entry of foreign lawyers in India.
So the thing is, if you look from the M&A perspective, this practice of a foreign law firm advising from the foreign law perspective and the Indian law firm advising on the Indian perspective was already there. It's still going on. So what difference does it make now? That has to be seen. How this notification is going to make a difference to this setup, which is already there. The question is why a foreign law firm comes to India for advising on its own law, which anyway it was doing from outside wherever they were or wherever their clients were. So what difference does it make? Let us try to understand this
Okay.
aspect.
Sure. So, Sandeep, my reading is while whatever might have been the advice of a foreign lawyer based on foreign law, insofar as Indian M&As are concerned, that advice did not remain attorney-client privilege from the point of view of Indian law. Now, it could be a privileged information and that privilege gets attached to it. Earlier, it could have been privileged in the host country. But in India, it did not have the same privilege, that of an attorney-client or attorney-product privilege. This will now qualify. Secondly, look at the taxation perspective. And we've been sufferers of this till now. Is when we on the patent application. I mean, we do patent applications almost about 2 patent applications a day across the globe that we register. You see, we take help of patent associates in most of other countries. Now, while my client is in India, I am taking services fee in India from this client, and I'm engaging a patent attorney for filing patents, let's say, in Switzerland. It is at that point in time that I do not get the advantage of input tax credit, neither do I get the advantage of reverse chargeable mechanism insofar as taxation is concerned. Because the foreign lawyer that I am engaging is not an advocate, is not a lawyer under the Advocates Act in India. Now, if that firm or that patent attorney were to register in India, you see, I will have a straight advantage of almost about 18% in many cases to 24% in few cases of the GST reverse chargeable mechanism is concerned. Now that, in my view, is a huge advantage. Now, how many firms in India today do that? Very few. The impact is not very large, but the impact is there. And the impact in terms of ease of business, or let's say ease of engaging foreign lawyers is concerned, is high. The ease becomes much better.
Yeah, no, I appreciate that. But again, the question is how it is going to benefit the foreign lawyer as such. I don't see the benefit maybe from the Indian perspective, but what about the foreign lawyer? Why he or she should be interested?
So let's
Because
ask
the
Peter
fact-
this question.
Yeah, sure, Peter.
Okay, yes, I try to. It's a very interesting discussion. I can tell you maybe from the Swiss experience we had we are not part of the European Union, but since 20 06. We are part of some treaties with free movement, and also regarding the professions, and also regarding the legal profession. So every European lawyer can settle here in Switzerland and practice law in Switzerland in front of courts, going to courts, represent people in courts under their original name as a lawyer. So, for instance, a French lawyer can practice in Zurich as avocat, as it is said in French. And the Italian lawyer can practice as avvocato, because that's his professional name from the original. And he is when he's settling here and practicing here permanently, he is under the supervising authority of the local bar, for example, the Zurich bar, but also on his original bar in Rome or in Paris or wherever. So in case he has some issues, the Zurich bar will report it directly to the Rome bar. So we had at that time very, very heavy issues, and we were also having this kind of discussion, who is coming in and who not. And we had the same thing, you know, for advisory, we had already foreign lawyers. And because of for advisory, there is, at least in the European context, not supervising. It's not something which is the bar will necessarily intervene if something happens, but only for the court things, you know. And we had at the beginning, in the first year after 2006, we had some foreign lawyers coming here trying to settle, to be honest, but they all failed, because it's a it's you know, the court thing, especially the court system, is something really where you grow up and you really need to feel. So for me as a foreign lawyer, it's good to know that I can practice law in India without having an issue from the supervising authority. But I will never dare to go to court in India, because that is so far away from my education. And I think the same will happen in India when after a while, maybe there are people coming, there are foreign lawyers coming, settling, trying to get the share of the market, but certainly not in the court cases. And anything else in the legal, in the international trade, in patents, registration, arbitration, that's anyhow quite internationalized, according to me. And as I understand how the notification, it's really, it's not about having recognized your university degree. It's really practicing as a foreign lawyer locally. That's so for me. It's good to be safe, on a safe side, when I really, once I would like to open an office in India, I have no issue with the supervising authority, but I will never dare to go to court with one of my clients.
So, Samir, you wanted to add something, or I'll?
Yeah, just to what Peter says, that of course this notification does not allow the foreign lawyers to practice in courts in India. So now again, the issue still which is there is whether they would be the advocates, as under the Advocates Act defines in our country. Again, what you just mentioned, a similar situation will also happen in India, and we'll need to address that as well, what we can understand from a practice of a foreign law in India. Yeah, Jamshid.
Yeah. No, so a couple of things, and I'll just go back to my Canadian experience here. Whenever, I mean, one has sort of gone there, and of course, very interesting. I was actually invited to join the bar there as an exception. And so that's another story. But I think what was interesting is that although one could have actually appeared there, directly, as I think what Peter said is, I did appear, but I've always ensured that I took with the permission of the court, because I didn't want to step on the wrong side of, you know, someone objecting to it. So once you, and I think that's a universal practice anyway. I mean, tomorrow if Peter wants to come and address the court in India with the permission of the court, he's permitted. I mean, nobody will say no to that. So I think that kind of, takes away that issue. The other aspect is, you also have dual qualified lawyers, and solicitors. I think, I mean, one will have to look at, from their perspective. I would have really liked, somebody like Kushnama or someone like that who is sort of qualified both in Canada and in India, or whoever else, to have, given that perspective, but maybe another time. But so I think that is also an area. I the third thing which I actually sort of discussed this with a registrar of a court in Canada, the Supreme Court of British Columbia. The question was that I said, the question was that I said, you suppose you have an issue concerning Indian law, which you have to, address. Say somebody has come from Punjab and you have to address that. I said, will the court not address that? I mean, take that law into consideration. So she said yes. I said, then similarly, if I'm sitting in India, I can certainly, I mean, it may not, I can certainly refer to your law. I can certainly look at contracts. I can certainly look at, but the formal advice that is given is perhaps through a practitioner of a foreign, country, perhaps. But I can certainly sit in India and advise my Indian client on any law. That how does that matter? So I think that's very interesting. The other issue, Suhas, is something that also, the question of that in India, I mean, Peter, you'll be quite surprised that we don't take professional indemnity insurance. Okay. I mean, I'm insured because I practice worldwide. So that's another interesting.
No, I do, Jamshed, and I think now the newer trend is actually the professional indemnity insurance cover is unlimited.
You would be deregistered when you have no professional insurance here in Europe.
Absolutely. So absolutely correct. And taking a good, comfortable worldwide cover and it's very easy. It's available now in India. Perhaps that if that also happens, I think it will be a good step forward. But and the other aspect is the where internationally, I mean, I know we had some clients from China, etc. The law in India says that you don't have to necessarily give sign an NDC, for example, okay, because you are practicing in India, and that is because it is embedded in the Advocates Act, etc. So these are some interesting, subtle issues which come into play. But I mean, overall, I think we are all happy with the fact that yes, so I think the fly in fly out concept, as Suhas has very rightly said, I think that's great. It'll ensure better interaction and all the best practices in court that we've been fighting for. If that can come in, with this little sprinkling of people coming in on a regular basis, I think it will really help. So that's my two bit.
Yeah, sure. I think Jamshed, you're right. I think if we are able to kind of move the professional indemnity insurance cover needle a bit, that would be a large kind of an impact here. It's going to impact in various form and manner the practice. I mean, even for example, I would expect, based on whatever my experiences have been when I was into litigation, that the quality of pleadings, go phenomenally high. And I'll give you one example where I was retainer lawyer for Enron, as some of you know, and Enron wanted to file an SLP in Supreme Court. I had drafted the SLP and I got it weighted from few of the senior counsels in the Supreme Court, and they weighted the SLP. And I circulated it across to the global lenders who were at that point in time actually driving the business at Enron India. And I was prevented from filing that SLP in the Supreme Court by saying it doesn't have the requisite quality that we are used to. And I mind you, one senior partner from Linklaters flew into India. He sat with me for 3 weeks, in a hotel in Delhi, and then we revamped the entire SLP. It's at that point in time that I realized when you look at the audience, which was global lenders and not the judges in the Supreme Court, the quality parameters on a draft that came out, which is litigation draft, actually pleadings in litigation, tremendously was a much better draft that we saw. And that experience taught me to say that while your audience may be those judges in the Supreme Court, but you have clients who are international lenders, and they are going to kind of drive the quality up to what they are used to. Even if that were to happen to Indian litigation scenario because of even this fly in and fly out being unrestricted practice, I think that would be a great quality parameter coming in. Because once you have few clients having these kind of pleadings, I think we all know how India copies and pastes the quality across the legal pleadings.
I think, as you rightly said, that you see, good competition is always welcomed, and in a general open-ended way, we should be welcoming this to help us to better our own intellectual knowledge and experience. There's no doubt about that. But there are a set of practitioners or a group of Indian practitioners who are not so keen even now. So, but all said and done, I think it's a very positive step by the government for whatever reasons. I mean, all these issues or loopholes or clarification will come, of course, because it's a big step. It will need to be taken, in a proper format, considering the benefits that would happen to our own country. But it's a right step at the right time, I think, and we should be welcoming this.
Samir,
Definitely, I think
I'm so sorry. Samir, what about Gift City? I thought that was an interesting exception.
Yeah.
I was coming to that.
Yeah. So from a Gift City perspective, I think that was never ever promoted by us as well as the foreign practitioners, because Gift, if you see the purpose of Gift, there was the one of the three main aspect of establishing Gift was giving a international quality dispute resolution mechanism to the people who are coming to Gift. That was, if you read the Gift's objective, this is the third main objective of Gift. Somehow that was never encouraged, that was never promoted, because even without this notification, these practitioners could have come and settled down in Gift and practice their own law. That was very unfortunate, but I think now this will get more promoted. A couple of practitioners in even these institutions, Singapore International Arbitration Center actually started there in Gift, but couldn't make it out for various reasons. But yes, it's a very, I think, important aspect now, which we from ILA should be considering and promoting within our members from a Gift perspective, and to also take advantage of this notification.
Right. No, I completely agree with you, Samir bhai. I think there is a tremendous potential there in Samir bhai. There is tremendous potential there in the gift IFSC, and I think we should actually look at that impact as well. I mean, as we progress further from ILA
Yeah,
perspective, Jamshed, I think we should look at the impact there. See, on a very lighter note, I think before, I mean, we log off, I mean, what is the reciprocity? And I was talking to one of the very senior solicitors in London, and he said, "What is reciprocity for you guys, for Indian lawyers or Indian?" Uh, he says, "I have seen the lawyer standing outside your Esplanade court in Mumbai. I have seen lawyers standing outside most of the courts in India today. There are hordes and hordes of lawyers. The numbers are mind-boggling. And if by the reciprocal arrangement you mean that Silk Street would be flooded with Indian lawyers standing there on the road, I think where are we heading towards on the reciprocity?" was his question. Because we will find a way, Jamshed. Indian lawyers will find a way if there is reciprocity as to how to stand there and try to get some mandates moved out. And I think that's a scary situation from a global law practice. And just on the lighter side.
Yeah. And also on a lighter side, I think, this is apart from what Samir Bhai has said, I think for ILA, I think we'll be very happy to go and say that, look here, if you don't have to spend 40, $50,000, you can align with us, and we'll probably have the smoothest and the best global practices without any problem anyway. So, so I
That's
think
right. That's right. That's right.
there is
That's
no issue, and I think that's a great way ahead. And maybe I think the important aspect, one of the important aspects of actually starting ILA was to get across boundaries, geography especially. That was very, very much sort of on my mind when we did that. And I think to a very interesting sort of uh, we've actually been able to succeed, I mean, in doing that. And I think uh, just for a minute, because like the British barrister, see, usually they don't have any problems at all. If you go there, even if you're advising with them in conferences, in fact they welcome your expertise, on that aspect of the law. And I think, and vice versa, as you said, you had somebody from Linklaters coming down and sitting with you and working on a draft. I think so that aspect of uh, lawyers working together on a given brief, and this, I think that is the internationalization. It is very much prevalent formally in arbitration, but I think in litigation it is more subtle and keeping these parameters, unfortunately. But I think it's fine. I mean, where is the problem? The only question is, I mean, like for example, in Canada, he was looking at my gown and saying, "Your gown is so light." I said, "Yes, because the weather conditions are different. Otherwise, there is no problem."
and we don't wear the wigs.
so Jamshed, one suggestion about this ILA part. I think to take it forward as a next step, follow up to this discussion. Why don't we involve somebody from the government side next time, who is maybe dealing with this particular notification, maybe from the BCI side or from the government, to try to understand their understanding of this notification, what actually they meant by this when they drafted this, and what is the meaning behind when you're opening up of the legal services. Let's try to understand their perspective also, to be on a better, to have a better understanding. We have discussed ourselves internally ourselves as practitioners, but let us understand the government side as well. What do you think?
Yeah, I think
My,
Suhas
see,
is planning. That is our next step.
yeah, so Samir bhai, what we should do is we should actually create a white paper on this as ILA's white paper. and then
Yeah.
reach out to either the Bar Council of India or basically the Bar Council of India, not really the Department of Trade,
Yeah,
not
yeah,
Government
of
of
course.
India,
Yeah.
because I've seen Government of India's papers that actually say we want to promote foreign law practice in India. So the Bar Council of India and Government of India are at the loggerheads on this issue, is my reading of the situation. Because Government of India wants to show to, let's say, the US, the UK, and other foreign countries that we are very progressive and that ease of business is being promoted through these means. But Bar Council is not so very open. But let's reach out. Let's prepare a white paper. We'll circulate that white paper and let's look at how do we kind of then reach it out to the governments and Bar Council both.
Yeah, sure. I mean, that's a good suggestion. So I think let's do that, and maybe through our own sources, we can connect with the Bar Council executive or somebody there to, have a discussion on this based on the white paper.
Yeah, so one other thing which I wanted to check with Peter, and I think we'll check with other lawyers from other jurisdiction is, would the trade association and trade bodies, let's say Swiss Indo Chamber of Commerce in India, would that take up these kind of causes? Because I think getting a clarity through the trade associations, which are representatives of the trade, I think, or let's say the embassies, the trade associates attached to the embassies, is that an option which can work better? Because our saying so, or our white paper being pushed across by Swiss Indo Chamber of Commerce or a trade attaché to the Swiss ambassador in India will have a different meaning altogether.
Good question, because these trade associations are usually really here for the companies, for the banks, for the pharma industries and things like that. It's not usual that, I mean, lawyers are member of these associations, but it's not the legal service as a good to be traded is not that common. So and usually these associations have their own intern legal staff to provide services, especially in the trade. But what I would suggest is really the Swiss embassy in India and the other way around, the Indian embassy here in Switzerland. They could promote that, and certainly the local bar associations. I'm sure that Zurich Bar, Geneva Bar, they are very well interested in these kind of topics. I'm sure I can connect you with all these kind of institutions here. Indian embassy, I know these people very well, and also certainly the bars here. We had recently in the last weeks a lot of newspaper articles about India, because India is now regarding the population the biggest country since about 1 or 2 weeks, something like that. So that was a topic, and also the idea that India is the 5th large economy in the world, which is quite important. And we had some good newspaper articles here about India in the last 3-4 weeks. Yeah.
So just adding to that, so as what you correctly pointed out, in fact, I have already started doing this in New York. I'm trying to organize a meetup with the law firms and the New York International Arbitration Center, along with the Indian Embassy here, on this very aspect. Maybe in 2-3 weeks' time, and of course involving the New York bar. So that would be an interesting this thing, and I'll keep us the group updated on this. And if we can, try to open it up as a hybrid, yeah, that's what I'm saying. So I'll try to do that itself, so that our ILA can also be part of it that way.
Yeah, I'm ready to and willing to organize whatever you think is good, and when I would like to see what you're doing in New York, and then we can also do something similar here in Switzerland. Yes.
Yeah, but you're right. So I mean, maybe what we can do, we can organize this with the Indo-American Chamber of Commerce. They have a good presence in
Correct.
Mumbai. Like that, yes, that would be an interesting, because even the embassies, most of these embassies, they have a legal attaché with them, so we can go through them, and they would be interested, in this kind of an issue.
Mhm. Absolutely.
So I think from our side, I can say one thing, Jamshed and everybody, Samir bhai, is that we can circulate the first draft of white paper, and I think I'm going to
Yeah.
request Mayura. Mayura, you already have some sketch of the white paper, right?
Yes, sir.
Okay, so we'll circulate the first draft of white paper very soon, Jamshed, and I
Sure.
think let everybody contribute. Based on that, we can kind of then design a reach out campaign through trade associates, trade attaches, and Chamber of Commerce, etc.
Definitely.
I think
And maybe, sorry, maybe we can also try to get this the comments which have been sent by this committee, the self committee, to the BCI, just to understand their viewpoint as well.
very well. I think we've seen that, but that's a outlook of large law firms currently.
Doesn't, I mean, but anyway, but that also has to be
Anyway, we'll
considered.
take care of that.
Yeah.
Of course, we'll take care of that. We will include that in the white paper, and we'll kind of do a good job out of it. Get all comprehensive kind of writings and research papers out there.
Yeah.
Jaideep, you are on quiet. Any addition? Maybe he's just listening. Okay.
Jaideep, you're on mute.
No problem. Okay, I think wonderful. We crossed 1 hour. Perfect.
Yeah. Okay. Yeah. That's
And,
right. But thank you.
Thank
Thank
you.
you, everybody.
Yeah, thank you. And let's post this on the group and follow it up with the next session to make it, an interesting discussion.
Absolutely.
Yes, sure.
Wonderful. Thank you all. Thank you all.
Thank
Thank
you.
you. Thank you so much.
Thank
Thank
you.
you.
for the
Thank
insight.
you.
Thank you. Bye-bye.
Bye bye. Take care.
Bye.
Thank you.